The aim of this video is to shed light on the process and procedures involved in a disciplinary hearing. Once an employer has decided that there are sufficient grounds to commence with a disciplinary hearing, the employer must inform the accused employee in writing that the disciplinary hearing is to take place. This notification must be done in the presence of an HR officer. The notice must at a minimum contain the following information: the alleged transgressions, the date and time of the hearing and the venue. The employee should sign a copy of the notice to attend the hearing. Signing the notification is not an admission of guilt. It is merely proof that the employee has received a copy of the charges. If the employee refuses to sign the notification, the employer will arrange for it to be signed by the employee's representative or an HR officer. This should be done in the presence of the employee. The employee must be given sufficient time to prepare for the hearing. As a rule, employees are not entitled to legal representation. However, the employee is entitled to be assisted by a fellow employee or union shop steward. The employee is entitled to an interpreter. The employee is entitled to call witnesses to testify on his or her behalf. The employee is entitled to cross-examine the initiator's witnesses. If the employee fails to attend the hearing without giving a valid reason, the hearing will be held in his or her absence. At the commencement of the hearing, the chairperson will explain the reason for the disciplinary hearing and will advise the employee of their rights, as contained in the charge sheet. The chairperson will read the charges to the employee and make sure that the employee understands the charges. The chairperson will explain how the disciplinary hearing will be conducted, indicating which party will begin, how witnesses are to be examined, and other procedural matters. The employee is given the opportunity to enter a plea of guilty or not guilty. If the employee admits guilt, the chairperson will hear mitigating and aggravating arguments. If the employee pleads not guilty, both the initiator and the employee will be asked to make opening statements. The opening statement is a brief summary of the case, including an outline of the issues in dispute. The employee briefly explains how the allegations will be disproved during the course of the hearing. The initiator starts the proceedings by stating the employer's case, presenting evidence and calling witnesses. The employee is given the opportunity to present evidence disproving employer's case. The employee can also call witnesses and is entitled to cross-examine the employer's witnesses. The initiator may refute the evidence of the employee and has the right to cross-examine the employee's witnesses. During the course of the hearing, the chairperson is entitled to ask both parties questions in order to establish clarity. Both the initiator and the employee will be asked to provide closing statements. The chairperson will ask both parties to submit factors in mitigation and aggravation within a stipulated time period. The proceedings will then be adjourned. The chairperson will carefully examine all of the evidence and decide on a balance of probabilities if the employee is guilty or not guilty. If the employee is found guilty, the chairperson must decide on a suitable sanction by taking the following factors into consideration: the seriousness of the offense, aggravating and mitigating factors such as the employee's personal circumstances, length of service, previous warnings, and whether or not there has been a breakdown of trust in the employment relationship. The chairperson's finding must be communicated to the employee within a reasonable time period after the hearing. If an employee is found guilty or is dismissed, the employee must be informed of the procedure for lodging an internal appeal, if such a mechanism exists within the organization. If no such mechanism exists, the employee may refer the dispute to the Commission for Conciliation, Mediation and Arbitration. This must be done within 30 days from the date of dismissal. Thank you for watching this video. We hope you found it helpful. For further advice or assistance, please contact our offices on 07921300302 or labor and legal consultants at outlook.com.